Make an error on a standard commercial contract, and you might face a civil lawsuit. Misunderstand the mechanics of a legal retainer, and you risk strict financial liability and the sudden end of your professional career. The retainer is the foundational contract establishing the relationship between a solicitor and a client. But treating a retainer like any other service agreement is a dangerous trap. It is a highly regulated, dual-framework hybrid. Unlike standard contracts, the retainer starts with general contract law. Then, statutory implied terms drop in, like Section 13 of the 1982 Act, mandating reasonable care and skill. Finally, the SRA Code of Conduct caps the structure, strictly overriding standard freedoms. These professional conduct requirements are non-negotiable. If a client instruction conflicts with the code dictates the outcome, superseding standard business practices entirely. We are going to trace the chronological life cycle of this highly specific contract, starting at initial instruction, navigating execution duties, and ending at its termination. Mastering this dual framework is your primary defense mechanism in practice. It serves as the only firewall between a practitioner and catastrophic professional risk. This timeline maps the life cycle of the retainer. The initial phase is accepting instructions. This is often where practitioners are most vulnerable. At this node, SRA Paragraph 8.1 imposes a strict requirement. A solicitor must definitively verify the exact identity of the client. Verifying identity is a primary shield against becoming an unwitting party to property and title fraud. The severity of this requirement was proven in the Court of Appeal through two cases heard together, Dreamvar and PNP Property. These cases serve as the ultimate stress test for the instruction phase. The facts were straightforward. A fraudulent seller successfully impersonated a high-value London property owner. Relying on this, an innocent buyer transferred purchase funds to complete the sale. The fraud was only discovered after the money vanished. This schematic details the transaction mechanics. The buyer solicitor holds purchase money in a trust account with a fiduciary duty for genuine completion. The court found zero negligence by the solicitor. Despite that, they were held fully liable for their client's massive financial losses. Because the seller was an imposter, there was no genuine completion. Releasing the funds under those conditions constituted a strict breach of trust. This liability overlaps with a secondary statutory duty. Under the Money Laundering Regulations 2017, practitioners must obtain satisfactory evidence that their clients are exactly who they claim to be. The takeaway is absolute. A solicitor's duty to safeguard the transaction supersedes their lack of negligence. Identity verification is a matter of strict financial survival. The instruction phase carries a parallel risk when dealing with third parties who claim to speak for the client. The foundational rule here is precise. A solicitor can only act on instructions directly from the client or from an agent who is properly and legally authorized to provide them. The 2008 case of Warner v. Masefield illustrates the cost of ignoring this rule. A firm issued court proceedings on behalf of two trustees, but had only taken instructions from one, assuming that trustee had authority for both. By taking an active step in litigation, a solicitor warrants to the court that they have explicit authority to do so. Operating without it breaches implied authority, and the court ordered the firm to personally pay the legal costs of the other parties involved. Beyond simple authorization, third-party instructions introduce severe ethical risks regarding duress and undue influence, particularly when vulnerable or elderly clients are involved. This node network maps a high-risk scenario. Node A is an elderly client. Node B is her son, Alfie. Alfie acts as the third party, instructing the solicitor at Node C to transfer his mother's house into his own name. Under SRA Paragraph 3.1, a solicitor presented with an absent, vulnerable client gifting a major asset to the person delivering the instructions must suspect undue influence. The practitioner must refuse the immediate instruction and block the transaction. Executing a client's stated wishes is secondary to ensuring those wishes are free from coercion. Professional conduct requires you to actively filter and occasionally block incoming instructions. Once a retainer is securely established, we enter the execution phase, where a specific set of ongoing duties binds the practitioner. The baseline is the implied statutory duty of reasonable care and skill, mandated by Section 13 of the Supply of Goods and Services Act 1982. Historically, advocates enjoyed immunity from negligence claims for their conduct during court proceedings. The House of Lords removed that protection in Arthur J.S. Hall v. Simons, exposing solicitors to negligence claims for both non-contentious work and active litigation. But avoiding negligence is only the floor. The solicitor-client relationship is defined in common law as a fiduciary relationship. The solicitor is legally bound to put the client's interests before their own, meaning any secret profit or third-party referral commission must be fully accounted for to the client. We can see how strict this fiduciary duty is by mapping an own interest conflict. If a client instructs a solicitor to draft a will including a gift exceeding 1% of the client's estate, the scale immediately tips. This automatically triggers a legal presumption of undue influence. To rebut this presumption, the solicitor must decline the instruction unless the client receives independent legal advice. Only that external validation can balance the scale. There is a narrow exception. If a practitioner is drafting wills for their own parents, and the surviving parent leaves the residuary estate equally among the solicitor and their siblings, the SRA notes it may be appropriate to proceed without independent advice. The fiduciary framework inherently distrusts practitioner self-interest. It legally requires external validation for any action that disproportionately benefits the solicitor at the client's expense. This split-screen schematic brings us to the final stage, termination. Notice the extreme power imbalance. The client possesses the absolute right to terminate at any time, for any reason. By contrast, a solicitor's rights are heavily restricted. A practitioner cannot simply drop a client. A solicitor must justify withdrawal with a legally recognized good reason, such as a client demanding a breach of law. Furthermore, you must provide reasonable notice. Walking away right before a hearing violates professional conduct. A retainer can also end through termination by law, where the contract dissolves automatically outside the direct control of either the solicitor or the client. This occurs in two primary instances: if a sole practitioner is declared bankrupt, or if the client loses mental capacity under the Mental Capacity Act. Upon termination, the practitioner faces immediate administrative responsibilities. Unbilled client funds must be returned promptly, with interest, and the solicitor must manage the transfer of physical and digital paperwork while adhering to data protection rules. However, if the client terminates the contract while leaving legal fees unpaid, the solicitor holds one final point of leverage: the legal lien. Under common law, a lien is a legal mechanism that allows a creditor to retain possession of a debtor's property. For a legal practitioner, this means holding on to the client's physical papers until the proper legal fees are completely settled. But even this power is not absolute. Under Section 68 of the Solicitors Act 1974, the High Court, or the SRA during a practice intervention, retains the authority to order the mandatory delivery of those papers back to the client. From the first moment of instruction to the final transfer of files, the retainer operates as a structurally asymmetric framework. It places the vast majority of the risk, the ethical burden, and the requirement for justification entirely onto the legal practitioner to protect the public and the integrity of justice.